Thank you for joining me in this discussion of the attorney-client privilege and more. You remember me, I'm Patrick McGinley. I am your friendly neighborhood bar grievance defense attorney, by which I mean I'm proud to defend my fellow lawyers who are members of the Florida Bar, and lawyers who are members of the District of Columbia Bar, as I am, and defend them against bar grievances, ethics complaints, and help them to get out of trouble if they fall into it, or to stay out of trouble however I can help. So great. That's why I love to discuss topics of professional responsibility and of ethics, and I'm very proud to be your instructor for this semester at your law school. So today we are discussing many topics. We're going to pick up where we left off previously, by which I mean we're going to wrap up our discussion of conflicts of interest, and we're going to do so by discussing imputed conflicts of interest. These are conflicts of interest which you are thrust upon and that you get, possibly through no act of your own, simply because some other member of the firm brings with them a conflict of interest. When are conflicts of interest imputed? When can you, my fellow lawyer, have a conflict of interest based on someone else's knowledge, experience, or past representations? That is the first of our topics today. We'll cover that, and then we'll move to our main topic, which is the duty of confidentiality. Even before you became a lawyer, even before you went to law school, you were familiar with concepts such as the attorney-client privilege, the work product privilege. We're going to touch upon those from the perspective of professional responsibility. When is information confidential? What are your duties as to confidentiality? When can you share information that might fall under the category of confidentiality? When must you share such information? These are the kinds of topics we're going to discuss when we turn to our main topic today of confidentiality. And as part of that discussion of confidentiality, you probably noticed that your textbook highlights, cites to, and discusses the SCOTUS decision from 1998 called Swindler and Berlin versus United States. We won't neglect to discuss that opinion. Indeed, we're going to take a deeper dive than your textbook did into the facts and circumstances of that opinion. We're going to discuss the holding of that opinion. We'll discuss how the majority got to the outcome it got in that opinion. And we won't neglect to discuss the dissenting opinion signed off upon by three greats of SCOTUS lore. And we'll ask ourselves, perhaps, was the dissent correct? These are the kinds of issues we'll talk about when we look at the facts and holding of the Supreme Court of the United States 1998 decision in Swindler and Berlin versus United States. That opinion, as you may guess, talked about the duty of confidentiality and literally whether that duty survives. Oh, I just noticed if I touch the table, it moves the camera. That's got to be annoying to your eyes. I'll do my best not to touch the table. And when we take our break, I'll find another way to support the camera. Sorry about that flaw. I tell you, when you're both the presenter and the videographer, sometimes you can have flaws like that. I apologize. So we'll be talking about that duty of confidentiality. But we won't end there. We're also going to touch upon lesson 18 from our textbook. That talks about something near and dear to my heart, zealous representation. As I've mentioned many times throughout, touch the table. That can be annoying. As I mentioned, I'll back up from the table. As I mentioned, the table wasn't supposed to be one of our topics today. But anyway, as I mentioned several times throughout our semester, I believe that a lawyer should be a zealous advocate for her or his clients. And I believe that the model rules and the rules of professionalism as adopted in your jurisdiction do not rule out zealous advocacy. Indeed, I believe they encourage zealous advocacy. That's what I'm trying to do. I'm trying to encourage zealous advocacy. And I hope you'll agree with me that in a world full of injustice, our clients deserve nothing less than a zealous advocate for justice. So that's what the rules say you can be. I'm going to talk about some of those rules, such as 4.4, 3.2, 3.4, and much of Chapter 3 that highlight and allow you to be a zealous advocate. We're also going to talk about candor toward the tribunal. Must there be tension between candor toward the tribunal and zealous advocacy? Perhaps, but both duties can be met. We'll talk about exactly how that can be done. We will not end there, however. As you can see as I flip through the pages of my notes, we will talk about candor toward the tribunal and respect for the tribunal. Exactly what is it that we must be in addition to honest, fair, and courteous? We're going to get into the details of Rule 3.4, 3.5, 3.6, and the requirements there. We'll also touch upon, before we end our 3 hours together today, or fingers crossed, perhaps I can get it all covered in less than 3 hours. In our time today, we won't neglect to talk about publicity. Can a lawyer be engaged in the publicity that surrounds her or his litigation, transaction, or case? That's a question we will answer today. So there you have it. There you have a brief outline, a brief roadmap of where we're going. With that roadmap behind us, then, let's begin where I promised would be the beginning. Let's begin by wrapping up our discussion of conflicts of interest. To recap, as you remember, we've already exhaustively covered the requirements of Model Rule 1.7 and Model Rule 1.8, including a closer look at some of the differences we see when 1.7 and 1.8 are adopted on a state-by-state basis throughout our great nation. Basically, though, these concepts persist. We know that attorneys should not and cannot, without a waiver, represent a client if the representation of that client is directly adverse to another client, unless the attorney reasonably believes there'll be an adverse effect on the relationship with the other client and all the clients consent after consultation that reveals both the reasonable alternatives and the risks involved in the waiver. And despite that discussion, the clients give informed consent that you transmit back to them by way of something that meets your jurisdiction's definition of a writing. So we know that's true of Rule 1.7. We know that Rule 1.8 gives us some specific examples of exactly how to apply that rule when it comes to some of the more difficult scenarios that a lawyer might see. That's a recap of what we've already covered. You remember, as we wrapped up our discussion of Rule 1.8 and those difficult scenarios, all but the very last one, all but that very last scenario that I left you on in our very last videotaped meeting, all were scenarios that involved a conflict of interest that could be imputed. So with that cliffhanger, if you will, hanging out there from our last videotape discussion, when is it that imputation happens? When is a conflict of interest imputed? Here's a general rule. It comes from the Model Rule 1.9 and the concepts from it that have been adopted on a state-by-state basis. And there, if the client has formally represented by that lawyer, that same lawyer can't thereafter represent another person in the same or substantially related matter in which the interests are adverse to the interests of the former client. So when we take a closer look at the concepts that we find in Rule 1.9, specifically talking about duties owed to who? Owed to former clients. Yes, despite the fact that we've transformed what was once a current client into now the lesser status of being a former client, despite that transformation, still duties are owed. So this is one of two forms of an imputed conflict of interest. This one is a direct imputation. It is directly imputed to you as you move on from that client to other clients because you retained duties to your former client. Those duties include a duty to keep confidential information confidential, among other duties. Now, if you've formally represented a client in a matter, you can't thereafter represent another person in the same or substantially related matter if the person's interests are materially adverse to the interests of the former client, unless the former client, not the new client, not the current client, but the former client, gives informed consent. And you retransmit a writing to that former client confirming that informed consent. Now, I'm not going to rehash what it means for the consent to be informed consent because we've covered that in great detail. Likewise, I won't rehash exactly what it means for it to be a writing as defined under the model rules because the model rules do provide that definition, building on that knowledge that you already know. I remind you that it is a duty to a former client that persists despite the end of the former client's representation, that you avoid something materially adverse to that former client unless that former client gives informed consent if that materially adverse thing is in the same or substantially related matter. Let's explore that a little bit greater. If you're a fellow Florida lawyer, as I am, perhaps you've watched daytime TV and you can't avoid the personal injury law firms advertising there on daytime TV. One of the more common ads we see here in Florida is a lawyer who asserts that he is going to bring everything he learned on their side and use it on your side. Have you seen this advertisement? If you've not, the lawyer implies that the lawyer used to be an insurance lawyer working for the insurance companies and now works for you, the consumer, in bringing your claim against the insurance companies. And this lawyer's advertisement, to paraphrase it, says something along the lines of, what I learned over there on their side, I'll now bring to your side. And now I ask you, how can that be permissible? We know that it is permissible. There is nothing impermissible about that particular advertisement if you've seen it. Not only was it approved by the Florida Bar, but it does not violate either the rules regulating the Florida Bar or the concepts that you find in the model rules of professional conduct. I'm not criticizing that ad. I'm not even implying that it is inappropriate. It is indeed appropriate. There's not a violation there. I bring it up to ask if you know why that's true. Do you know why that's not a violation? Do you know why that ad is appropriate? Well, let's take a look at the concept embodied in the model rule, which persists and is also embodied in the rule regulating the Florida Bar, that makes this advertisement ethical, professional, and proper. What you see there is that you can't be materially adverse to the former client in what? In the same or a substantially related matter. This advertisement isn't saying, hey, you if you happen to be the adverse party in one of my old insurance company cases, come let me represent you now against my former employer. That is not what the ad is saying. And it could not be what the ad is saying, because those specific facts would be a violation of the concepts we see embodied in Model Rule 1.9 and found in its implementations, such as 4-1.9 of the rules regulating the Florida bar. It's okay to be adverse to a former client if it's not in the same or a substantially related matter. That's where we draw the line. That's where our duty to the former client ends. That's where the lawyer has some freedom to change sides, if you will. I like to point out that advertisement, not only because many of you in my audience are already familiar with it, it's been running here in Florida for years, but because many of you in my audience, even those who haven't seen the ad, can relate to it. You might imagine that in whatever field of practice you're in. You might change from doing plaintiff's work and then do defense work, or you might change from defense work and then do plaintiff's work. You might wonder to yourself as a law student, is that even possible? If I used to do defense work, does that mean I can never do plaintiff's work? No, of course. You can change sides in that way. What you can't do is, if there's a specific case once you change sides where you used to be in that same matter on the other side, then you can't take that specific case. But that doesn't foreclose you from changing specialties, changing sides. Maybe you used to be a proud insurance defense attorney and now you're a proud personal injury attorney. That's okay. That's permitted under Rule 1.9, under all the model rules and in all jurisdictions. What's not permitted is to change sides in that same litigation. If you used to be the defense attorney in that case, you can't become the plaintiff's attorney in that case. The key being, it's the same case. You can't change sides in the same case. The harder analysis is based upon the fact that the concepts of Model Rule 1.9 aren't just limited to the same case. They also apply to a substantially related case. Substantially related is also forbidden. For this, we put on our reading glasses because we want to read further into this rule. When are two matters substantially related? The answer comes from the official comments to the rule that has been adopted in your jurisdiction. The majority of those comments in the majority of jurisdictions are aligned with the following concept. Substantially related is when it involves the same transaction or legal dispute, or there's otherwise a substantial risk that confidential factual information would have been learned by that lawyer. So when are two matters substantially related? And as you hear me giving you this information, you're remembering that we covered this. We would cover this when? We covered this when we talked about government lawyers. Remember? Government lawyers who used to work for the government and then enter into private practice. Remember our exhaustive discussion about when it was substantially related? That same core concept is applicable right here. What you have here is that if you've got information from the prior representation, that information would materially advance what your new client is trying to do in this matter, then the two matters are substantially related. So the answer turns on not which side of the V you were on. The answer turns on what information you've got. Don't read that so broadly as to misinterpret it to mean that if you've gained knowledge and expertise on their side, you can't bring it to your side. Stated somewhat differently, just because, and you remember this discussion, just because you gain some insight into the knowledge and workings of government from being a government lawyer, that doesn't mean that you have information that's going to rise to the level of materially advancing the client's position insofar as to foreclose you from ever being adverse to the government. No, no, no. That's too broad a reading. If you read it that far, you've misread it. How can I remember that if I read it that far, I've misread it? Well, just remember that daytime TV ad. That'll help you remember. Remember what the daytime TV ad said, paraphrasing it? What I learned on their side, I bring to your side. Generally speaking, that's okay. Generally speaking, it's all right to gain knowledge and expertise and skills by having been on one side of this type of case and using that knowledge, expertise, and skills to launch a career that's primarily on the other side of this kind of case. So when that happens, that's okay. Instead, when you've got a violation, is when you have specific knowledge, so specific that it would materially advance the client's position in a subsequent matter. For example, extensive private financial information about a party. That's more than just having gained knowledge and skills and expertise. That's having gained knowledge that would materially advance the client's position in the subsequent matter. That's enough to call the two matters substantially related. What about other scenarios? What about a client is involved in getting environmental permits, building a shopping center? That person would be precluded from representing neighbors to that particular shopping center who's seeking to oppose rezoning of the property on the basis of environmental concerns. See the specificity there? See how that example, which I paraphrase from the official comments to the model rules, see how that factual scenario adds up to being materially advancing the client's position and therefore being a substantially related matter. So, bottom line, I've always been a plaintiff's attorney. Can I become a defense attorney? Yes. Can I become the defense attorney defending against my former plaintiff client? No. Those are two very easy examples to get right. And that's one way that a conflict of interest could be imputed to your new scenario. The fact that you yourself used to represent someone in that particular specific exact matter or substantially related matter. But there's another way that imputation can take place. There can be imputed to a firm, a group of lawyers, a conflict of interest based on the fact that any one of them used to represent someone in the same or substantially related matter. That falls under the concepts we find in Model Rule 1.10 of the Model Rules of Professional Conduct. Those concepts talk about how a lawyer who's associated with a group that meets the definition of firm, and that definition can vary from jurisdiction to jurisdiction. So in your particular jurisdiction, it's worth checking that out. The model rules provide a suggested definition of firm. Only some jurisdictions have included in their rules of professional conduct a definition of firm. The rest, the definition may be gleaned from the binding case law. But after you've confirmed what it means to be in a firm, when lawyers are associated in a firm in that way, none of them can knowingly represent a client when any one of them, if he or she was practicing alone, would be prohibited from doing so because of a conflict of interest found in Rule 1.7 or 1.9. So, is there a way around that? Yes, there is. Here's the first way around it. If that conflict is because of a personal interest of that one disqualified lawyer, and that personal interest is such that it doesn't present a significant risk of a material limitation upon the representation of the client by the others, then it's okay. So listen to all the requirements there. Let me break it down one by one. First, it had to be a personal interest of the one lawyer who brought the conflict and imputed it upon the others. You remember the various types of conflicts. Conflicts can arise in many ways. One of those ways is it might be a personal conflict, a personal interest of the lawyer, a personal experience of having been in a particular case. So first, if it's that kind of personal interest, right, and there isn't a material limitation, we gave a definition of that term. We gave many examples of what was a material limitation and what wasn't. Remember that prior knowledge. Use it again right here in Model Rule 1.9. So if you can avoid that personal interest of the lawyer from causing a material limitation, then we can avoid imputing the conflict of interest upon the entire firm. What's another way we can avoid imputing the conflict of interest upon the entire firm? Another way is that the prohibition came from a conflict with a former client, not a current one, okay? And arises out of the disqualified lawyer having done the work at a prior firm and not the current one, okay? So two instances of prior client, not current, prior firm, not current. And you do these many things. Got to do them all. I got to cover them one by one, but this is not an or situation. This is an and situation. Got to do all of these things. First, you've got to do what is currently called screening, which is not the clearest term of art here. It's a replacement for a prior term, which used to have to do with a walling off the lawyer. So you've got to screen the lawyer that has the conflict of interest. And in order to screen the conflicted lawyer, what you've got to do is wall her or him off so that she or he is doing more than just not participating in this particular case. He or she is not available to the lawyers who are participating in this case. It's as if by screening the lawyer, this lawyer is no longer part of the firm insofar as this particular screened case is involved. So when it comes to the physical files, the lawyer who's screened has no physical access to them. When it comes to the electronic data, the screened lawyer can't see it, can't read it, can't access it, has no access to that data. When it comes to the discussions among the firm, not just the lawyers to the firm, the paralegals to the firm, the legal assistants to the firm, the investigators to the firm, anybody and everybody in the firm. The screened lawyer isn't part of those conversations, can't hear those conversations, is not present for those conversations, is not contributing to those conversations. So there can be a factual analysis as to whether or not the screening is adequate. And believe you me, if you're in heated litigation and it's your opposing counsel who's seeking to disqualify a lawyer or a law firm and the defense is that they're screening, you're going to bet that there's going to be a close analysis to determine whether the procedures in place are adequate to ensure appropriate screening, to ensure appropriate wall is around the disqualified attorney to prevent that disqualification from being imputed to the rest of the firm. So what we're talking about here is not an easy task. The proper screening that is considered to be proper is not easy to accomplish, especially in a case big enough to involve much of the firm or perhaps involve all of the firm. So that's just the hardest part, and it's just the first thing that needs to be done on this list of ands, on this all-inclusive list, on this list of things where all of the things must be done. That was the first. The second thing that must be done, you got to let the affected former client know. And you got to let the affected former client know in a writing. You remember the definition of writing. Got to let him know in a writing. And you've got to be able, sometimes due to confidentiality rules, you won't be able to do this. You've got to be able to inform that former client of enough information about the screening so that the former client can determine whether there's compliance with the screening requirement. You've got to literally describe how the screening's being done and what the procedures are that are in place and how those procedures are being employed and how you're doing the screening. You're going to need to inform them, if there's a tribunal involved, that there is a tribunal which that former client could complain if the former client wanted to. And you've got to agree to respond promptly to any written inquiries or objections by that former client about the screening procedures. And remember, these were all ands. And you've got to provide a certification of your compliance with the screening procedures that you've adopted and provide that certification to the former client, not just once, but at reasonable intervals and upon the former client's written request and upon the termination of the screening. You've got to provide that not just from anybody at the firm, but from a partner at the firm. All these things are required. What's the bottom line? Is screening in this context easy? No. Is screening possible? Yes. Yes, screening is possible. But you're going to have to dot your I's. You're going to have to cross your T's. You may want to consider having in place a compliance officer. You may want to consider hiring a friendly neighborhood bar grievance defense attorney who has expertise in such matters to get involved and make sure that the screening procedures are in place and that they stay in place and that appropriate compliance is offered. Who knows? You might need expert testimony from a friendly neighborhood bar grievance defense attorney as to whether or not the screening is adequate, or perhaps an affidavit to that effect. You can see how whether the screening is adequate can become a litigated matter. You can see how keeping the screening adequate might be a matter that you might want to outsource to someone with adequate expertise to make sure that the screening is done and that it's done correctly. So that's the beginning of the requirements that we find arising out of the concepts of Model Rule 1.9. Also, when a lawyer quits and is no longer associated with the firm is not prohibited from representing someone whose interests are materially adverse to those of a client represented by the formerly associated lawyer and not currently represented by the firm, unless these two things are true. The matter is the same matter or substantially related to that, in which the formerly associated lawyer represented the client, and any lawyer remaining in the firm has information protected by rules 1.6 and 1.9c that is material to the matter. I resort there to just reading verbatim that quick clip from the model rules. What are we talking about here? What we're talking about is, what if a department, if you will, leaves the firm? Stated somewhat differently, what if a practice area, if you will, leaves the firm? What if, stated somewhat differently, a particular type of law is no longer practiced by the firm because one or more lawyers left the firm and took that type of practice with them? Can the firm then do similar work, but on the other side of the equation? And the answer is yes, as long as you followed those procedures I just talked about from the model rule. So if you're following me, what you're learning is that perhaps a firm used to practice in 4 or 5 different areas, one of which hypothetically might have been the divorce practice, focusing on a particular type of case, perhaps always opposing alimony. And perhaps the lawyer who spearheaded that type of practice leaves the firm and takes all those types of cases with her or him when leaving the firm. But the firm is still known in the family law circles. The firm is still known as one you might turn to for a particularly difficult alimony situation. Can the firm then focus on bringing alimony suits when the firm used to be known for always beating the claim of alimony? Stated somewhat differently, can the firm say, what we used to learn on their side, we now use on your side? And the answer is yes, if these requirements that I just went over are met. So not only can a lawyer gain knowledge and expertise from having worked on one side, and then that lawyer switches to another side, so too can a law firm change from one side and then join the other side if the firm and its remaining partners meet these requirements. Now, what about waiver? What if somehow we can't meet all these requirements and we can't satisfy some of the duties we owe to the former client? Can there be a waiver? And the answer is yes. The model rule literally says, turn to the concepts you saw in model rule 1.7, and the same waiver concepts can be found here. For that reason, I'll just remind you that we covered what it takes to get a waiver of a conflict of interest when you had 2 current clients and a conflict arose between those 2 clients. The same scenario is here. You can get the waiver when the conflict is not between 2 current clients, but is between 1 current client and 1 former client. So a waiver is a solution if it's available. Remember, we discussed what it took to be available. And if it's properly done. Remember, we talked about what it takes to properly implement and get a proper waiver. All that remains true here. So these are some of the concepts that you need to know when it comes to an imputed conflict of interest. Let's talk out loud and think out loud of some scenarios, and let's determine whether there's a conflict of interest there because of the former client. And I do this with you off the cuff. But I do it with you to encourage you to do this too. As a law student, studying a class that is rules-based, in my humble opinion, one of the best ways to learn those rules adequately is by drills, is by examples, where you look at the rule and you think up a scenario and you try to apply the rule to that scenario and get the right answer. That's why in my class I assign to you these computerized multiple choice quizzes that require you to take every week. And I know once you choose one of the answers, the computer immediately tells you whether you were right or wrong and tells you why you were right or wrong. But I think that's a great way to learn any rules-based case. I never actually sat down and watched from beginning to end that famous movie called The Paper Chase. And I should be even more embarrassed to admit that I never read even a single word of that famous book called The Paper Chase. So when it comes to the specifics of that award-winning novel and that famous movie, I'm the wrong guy to ask. But I did once see a short clip from the movie The Paper Chase, where I guess it was the main character, maybe a friend of the main character, had locked themselves up in a hotel room while studying for a law school exam. And those brief clips, if I remember them right, of what was going on in that hotel room was all about the work, was all about the studying. But they were studying, if I remember right, in a particular way. They were asking themselves, well, what if the facts were this? Then what's the outcome? What if I change the facts ever so slightly to this? Then what's the outcome? What if I then change the facts again, less slightly, more drastically? Then what's the outcome? And the movie portrayed these law students doing that for hours and hours, end on end. Now, I don't know what time constraints you're facing as an individual. Probably you can't lock yourself up in a hotel room for days on end doing these kinds of drills. But to the extent you can find the time to do drills like that, when it comes to a rules-based case like class, like professional responsibility here that we're studying together, I think that is an invaluable way to learn the rules. You want to get beyond mere memorization, and you want to get higher into implementation in order to best understand and know and use these rules that you're studying. So let's do that for a minute, shall we? Let me throw out some hypothetical scenarios, see what the answer is as we apply the rules, and then let's tweak them a little bit and see if the answer stays the same, and then why, or let's see if the answer changes, and then why. Sound like fun? Maybe not, but valuable. Whether or not fun, I can't tell you, but valuable, I believe it is. So here we go. All right, let's say you're a lawyer, okay? In Smith versus Wong, I'm making up names. Any similarities to a real case is purely coincidental. So you're the lawyer for plaintiff Smith in Smith versus Wong, okay? And then you leave that firm. So you're no longer representing Smith. Smith left the case behind at the old firm with the old lawyers who used to be your co-counsels. Now they're the sole counsels because you're no longer an attorney of record on Smith versus Wong. You left the firm and you withdrew from the case. So now you're at the new firm. And for whatever reason, Mr. Wong comes knocking. Mr. Wong is thinking of adding the new firm to his defense team as one of the defense lawyers, part of the defense team in that case of Smith versus Wong. Okay, so there are the facts. First question, can you be lead counsel defending Mr. Wong in Smith versus Wong? That would be a conflict of interest. I hope we can all agree that that's a conflict of interest. Why is that a conflict of interest? Well, clearly, it's the same matter. We don't need to dive into whether it's a substantially related matter, because under our hypothetical facts, we've got the same matter, right? And you're attempting to literally switch sides to move from one part of the V to the other part of the V in the V that stands for versus. You would no longer be for Smith in Smith versus Wong. You would be versus Smith in Smith versus Wong. A clear conflict of interest. I hope we can all agree that that's true. So could you be lead counsel for Mr. Wong in Smith versus Wong? The answer would be no. Now, you've joined a new firm. Mr. Wong is thinking of bringing on the firm. Can the firm join? Well, I think it's also clear, hope you agree with me, that your conflict of interest is imputed. It is imputed to the new firm, is it not? Clearly, I believe the answer is yes. How do I come to that conclusion? Well, now I'm thinking of the concepts of Rule 1.10 in the model rules. There we know that if any lawyer associated with the firm couldn't knowingly represent the client themselves, then that conflict of interest becomes imputed to the rest of the firm, does it not? Yes, it does, under the concepts of Model Rule 1.10. So the quick and short answer is that there is an imputed conflict of interest to your new firm. If Mr. Wong comes knocking and looking to hire your new firm when you used to represent Mr. Smith in the litigation of Smith versus Wong. The harder questions are, what can the firm do about that particular conflict of interest? Well, that goes to the matter of what is called under the model rules screening. Think of that as some sort of a wall. Indeed, under former case law of years gone by, there was a reference to one of the seven man-made wonders of the ancient world, one of which that could be seen from space, a wall so big and so great. They used to describe that you needed this kind of wall in order to satisfy screening. We no longer use that archaic term. We now talk about screening, but you remember the severe and difficult requirements that had to be implemented in order to have screening. So it's not unlike so bold and visible a wall that you could see it from outer space, right? So then you're going to need that kind of screening and all the requirements that we talked about. So there's an example of how you might drill yourself. And of course, you can go farther. What if they did this? Is that enough screening? What if we added this and that? Is that enough screening? What if, as time went on, they stopped doing that? Is that enough screening? You can go farther with your own hypotheticals, with your own drills, if you will, to help you begin with memorization and rise to the level of comprehension, because that's where you need to be when it comes to the model rules of professional conduct, when it comes to the rules regulating the bar of your state, and when it comes to any law school class that is rule-based. So do those kinds of drills among one another. And if you don't have someone to bounce these kinds of ideas off of, I hope that the software I've assigned to you helps you do just that. So with that noted, we have finally, after all these hours of lecture, we have finally covered what we need to cover when it comes to conflicts of interest. Since we have covered what we need to cover, we're going to take a bit of a break, approximately 6 minutes. So if you're not watching live, if instead you're watching on the bottom here of the recording, you can slide, as you know, and you can fast forward for 6 minutes. Go ahead and fast forward for 6 minutes and my break will be over. And then we will begin our discussion of the duty of confidentiality. For those watching live, I'll see you in 6 minutes. Thank you for the break. Hey, thanks everyone. Thanks for the break. I guess we all need a break from time to time, do we not? Hope I didn't run too many minutes past the 6 minutes as I promised, but I guess we're about 6.5 minutes of maybe even 7 minutes of a break. Sorry, your time is valuable. Not trying to waste it, but thank you. Thanks for taking a break. If there's one thing we probably all need a break from, it's from talking about conflicts of interest. I went a little over time when it comes to discussing conflicts of interest, insofar as our syllabus contemplated that there wouldn't be any conflict of interest discussions today, that would have all been wrapped up before today. But when it comes to the difficulty of concepts that are covered in a professional responsibility class, I think most of us would agree that conflicts of interest wouldn't fall all the way on the low end of super easy. Maybe some of us would put it even further than the middle of somewhere balanced between easy and hard. I think most of us would put it toward the hard end. Maybe it's not the most difficult concept we'll encounter, but it's certainly closer to most difficult than it is to most easy or easier or easiest. I got to get my vocabulary right there. So for that reason, maybe I was beating a dead horse. Maybe I was covering the same concept more than once. Hey, that's the beauty of being able to fast forward on these films, right? So there you go. But anyway, I'm hoping that I'm serving you well. I welcome your feedback. I hope these videos are helpful to you, and I hope that they enhance your study and your practice of law. So with that said, what is our next topic? Finally, we move on to our next topic. And as we move on to our next topic, what we talk about is the topic of the duty of confidentiality. We're talking about here a duty that arose and a privilege that arose in the common law long before there were mandatory bars that a lawyer had to be a member of in order to be licensed into practice, long before there were model rules of professional conduct, and I dare say, depending on where you are, long before there were rules of professionalism in your particular state. I bet there were common law privileges that told us when information was privileged and confidential. Common law privileges such as the attorney-client privilege. Common law privileges such as the work product privilege. In no small way, the model rules of professional conduct and your state bar's mandatory rules of professional conduct are an incorporation and a restatement of those common law rules. We're going to see that as we study these rules so much more closer. We're going to look first at the concepts that we find arising out of or reflected in Model Rule 1.6. And that specifically talks about confidentiality of information. A lawyer is someone that a client should know the lawyer can share their confidences with. The public policy behind the fact that a lawyer gets to keep the confidences of his or her client confidential is so that the client can have the confidence of knowing that what they share with the lawyer can be true and complete, so that the advice the client gets from the lawyer is appropriate and adequate. What we're looking for is the public who are hiring lawyers, either individually or through their organizations, corporations, churches, families, or groups, are able to get the knowledge they need, the advice they require. Because if the client is fearful and holds back and doesn't give full disclosure to their own lawyer, then perhaps the lawyer is unable to give thorough and necessary advice. And there's a great desire for the lawyer's advice to be adequate, so that the public is well served by the advice being received by the lawyer. By analogy, there is in the common law of most jurisdictions and in the statutes of most jurisdictions other privileges of confidentiality. For example, the priest penitent confidentiality or the physician-patient confidentiality. When we think about those privileges, such as priest-penitent, we want the penitent to be able to practice her or his religion. We want the priest to be able to give the benefits of the priest's religion upon the penitent. Likewise, when we look at the physician-patient relationship, we want the patient to be able to get the right medicine, the right treatment, the benefits of the medical profession. We don't want those benefits denied by holding back, by non-disclosure. By analogy, we take those two scenarios and we apply them potentially to the lawyer-client relationship. In a not asimilar way, we want the client to be able to benefit from the legal representation, to be able to seek justice within the American justice system, and the confidence of knowing that secret information, confidential information, will remain secret and confident. That helps for the legal system to deliver the benefits that society needs. So it's easy to criticize some, perhaps even many, rules that regulate bars as being beneficial to the lawyer first and foremost, but maybe not so when it comes to keeping the confidences of one's clients. It's certainly a burden to keep information confidential. There are exceptions, but when those exceptions don't apply, sometimes there might even be a detriment to the lawyer who's burdened with the confidentiality. But that's one of the duties we assume as lawyers and as part of this great profession of ours. So, with that preface in mind, let's take a closer look, shall we? Let's put on our reading glasses and read very closely the requirements of the duty of confidentiality of information that arise out of the common law, but that are reflected in state court rules and in rules regulating state bars and in Model Rule 1.6. There, we know that you shouldn't reveal information relating to the representation of the client unless either there's informed consent. We already went over the definition of what it takes for the consent to be informed, or there's implied authorization for that particular disclosure because it's needed to carry out the representation. Or one of these things apply. And now, on the these things list, I turn first to the model rules. But what you're going to find is great discrepancy, great differences between the model rules and your state's rules. So I'll begin with how this list appears in the model rules. But then let me throw in salt and pepper on top of a fine piece of steak or fish or pork or chicken. Let me sprinkle, if you will, some references to some state rules so you can get a taste for the differences. First, the model rules. A lawyer may, this is not must under the model rules, this is may. A lawyer may reveal information relating to the representation if the lawyer reasonably believes it's necessary for one of these reasons. First, to prevent reasonably certain death or substantial bodily harm. Second, to prevent a client from committing a crime or fraud that is reasonably certain to result in substantial injury to the financial interest or property of another. and in furtherance of which the client has used or is using the lawyer's services. Third, to prevent, mitigate, or rectify substantial injury to the financial interest or property of another that is reasonably certain to result or has resulted from the client's commission of a crime or fraud in furtherance of which the client has used the lawyer's services. Or fourth, to secure legal advice about the lawyer's compliance with these rules. Or fifth, to establish a claim or defense on behalf of the lawyer in a controversy between the lawyer and the client. Or to establish a defense to a criminal charge or civil claim against the lawyer based upon conduct in which the client was involved. Or to respond to allegations in any proceeding concerning the lawyer's representation of the client. Or to comply with another law or a court order. Or to detect and resolve conflicts of interest arising from the lawyer's change of employment or from changes in the composition of ownership of a firm, but only if the revealed information would not compromise the attorney-client privilege or otherwise prejudice the client. And the last thing that Model Rule 1.6 notes after that long litany of ors, all of which didn't require but may permit a lawyer to reveal the confidences of a client. The last one is the following. It's a must. The last one is a lawyer shall make reasonable efforts to prevent the inadvertent or unauthorized disclosure of or unauthorized access to information relating to the representation of a client. So let's look a little bit closer at the model rules list. Before, like salt and pepper, we sprinkle on top some of the differences we'll see from state to state. First, one thing we note in the model rules, what about a crime? Under the model rules, what if the client has committed a crime? Well, under the model rules, if when the client in the past committed the crime, the client used that lawyer's services in the commission of the crime, then the model rules are satisfied and the lawyer may reveal the confidences of the client. Now, the model rules obviously are just a model rule. They're not the actual rules in any jurisdiction. So on top of the model rules, you've got to think about the actual rules, and you've also got to think about the actual law, the criminal law. The license to practice law is not a license to commit a crime. The lawyer is subject to all the criminal laws and statutes of the jurisdiction, just as any other citizen would be. There could be accomplice liability for a lawyer who learns that the lawyer's services were used in committing the crime, and then the lawyer does nothing about that after obtaining that knowledge. That's going to depend upon the laws of the particular jurisdiction. You'll need to look there. But in addition, under the model rules, you do have permission to comply with those criminal statutes. Of course, the model rules should never be interpreted to require a lawyer to commit a crime. Indeed, there are no rules of professional conduct that excuse the commission of a crime by a lawyer. So to the extent that your jurisdiction's statutes might, I hope I got that, to the extent that your jurisdiction's statutes might create criminal liability, don't try hiding behind the rules of professional conduct. They are not an excuse for committing a crime. So even if it's not the crime of murder, even if it's a civil situation that would reasonably certain death or substantial bodily harm would arise, that satisfies the model rules and says that you may disclose under that. What if the crime or fraud is reasonably certain to result in substantial injury to the financial interest or property of another, and the client has used or is using the lawyer's services to do that. That's the second one we talked about. That was another scenario where, yes, the lawyer may disclose. Another scenario under the model rules is when the crime has already happened and it involved the client using the lawyer's services to commit the wrong, but it was not a crime. It was tort. It was a breach of contract. It was financial interest or property of another that was harmed. Then, under the model rules, the lawyer may disclose the information. So what you've got there under the model rules, in all those circumstances, it was when the client's past wrongdoing, either criminal or tortious, involved the use of the lawyer's services. What if the client's past wrongdoing did not involve the use of the client's past services? For example, say you have a client, and because you represent the client, you somehow learn that the client was a dirty, rotten contract breacher in the client's past. Had nothing to do with you, wasn't a breach of contract procured through your services. Indeed, you didn't even represent the client back then, but now you find out that indeed the client was a dirty, rotten contract breacher in their past. Do you have permission? Do you have the liberty under the model rules to disclose your client's dirty, rotten contract breacher status? No. No, you do not. To the contrary, you have an obligation under the model rules in that particular factual scenario to keep quiet, to keep confidential the fact that in the past your client was a dirty, rotten contract breacher. Why is that? It's because that past behavior did not involve your services. That's the key. Let's take it one step farther. Again, we're talking about knowledge you acquire through your representation, and you learn that before you represented this client, indeed, this wasn't done through your services or with your help. It wasn't even done while you represented this client. It was done in the past, and it was worse than a dirty, rotten contract breach. It was an actual crime, an unsolved crime, where the police are still trying to solve that crime. Now, may you come forward and help society and say, hey, police, I found the criminal. Right here, it's my new client. Here you go. No, you may not do that. And if you do, you have violated this rule of professional conduct, Model Rule 1.6. Why is that? Again, under that factual scenario, the past crime did not involve your representation. The client didn't misuse you as a lawyer and use your services to commit that crime in the past. So you are not at liberty under Model Rule 1.6. You do not have the discretion under Model Rule 1.6 to disclose that information. Indeed, you would be violating your duty of confidentiality under those facts if you were to reveal that information that you learned through representation. Let's make it even harder. Same facts, new client just started representing her or him or it. And in the past, before you represented, through no help of yours, through no use of your services, in the past, this client committed murder. Worse than a dirty, rotten contract breacher. Worse than just a criminal on the run. You found out about a murder. An unsolved murder. Under Model Rule 1.6, can you bring that little bit of solace to the victim's family? Can you bring that much needed justice of helping to solve an unsolved murder? Can you report to the police the information you learned about your new client? Under those facts, the answer is no. No. No, you cannot share that information you learned by way of your representation, because if you do, that would be a violation of Model Rule 1.6. Why? The murder didn't happen on your watch. The murder didn't happen while you represented the client. The murder didn't happen through use of your legal services. The murder didn't happen through your being an accomplice or a help or a tool of that murder. It seems egregious, does it not? But it remains true that would be confidential information which you are obliged under Model Rule 1.6 to keep confidential, and that you do not have the liberty to disclose under Model Rule 1.6. So as I mentioned at the onset of our discussion, these rules can be a burden upon the lawyer. That's certainly a factual scenario where this would be a burden. Can you imagine having to keep that information confidential? Can you imagine, as our textbook says, and to quote it, keep it to yourself forever, end quote. Can you imagine having to do that with murderous information like my hypothetical just identified? That would weigh heavily on the lawyer and on her heart and on her soul. But it would be the required outcome of Model Rule 1.6, for better or for worse, under those particular facts in my hypothetical. So, when it comes to the model rules, states differ. Perhaps my hypotheticals helped illustrate why states might differ. You can see how some states are not going to sign off on this 1.6 as is. Let's take a look at some of the differences that you would see from state to state. And I'm thankful for this research that is embodied in this particular book, of which I'm flipping through. So this book identifies some of the differences you would see. For example, in Florida, what if disclosure would prevent serious bodily crime? In Florida, the lawyer is obliged. The lawyer must reveal that information. That's Rule 4-1.6 sub B sub 2. In Florida, what if revealing the information would prevent a non-bodily crime? Still, the lawyer must reveal the information under rule regulating the Florida Bar 4-1.6 sub B sub 1. What if revealing the information would prevent a non-criminal fraud? So the civil fraud, not the crime of fraud. There, the Florida lawyer must not reveal the information. That's the outcome of rule regulating the Florida Bar 4-1.6. What if revealing is something that would rectify a past crime or a past fraud in which the lawyer's services were used? Unlike the model rules, rule regulating the Florida Bar 4-1.6 would apply and mean in Florida that the Florida lawyer must not, N-O-T, must not reveal the confidential information, even if revealing it would rectify a past crime or a past fraud, even if that past crime or that past fraud was done by using that lawyer's services, that Florida lawyer's services. In Florida, under the rules regulating the Florida Bar 4-1.6, still the information remains confidential. The Florida lawyer under Rule 4-1.6 must not reveal information to rectify past crime or fraud, even when that particular lawyer's services were used to commit that past crime or fraud. What about fraud upon the court? The Florida lawyer under Rule regulating the Florida Bar 4-3.3 sub A sub 2 must disclose the confidential information if that information works a fraud upon the court. So you can see there some very real differences, some very different outcomes in, for example, Florida versus the model rules. Let me turn to the other jurisdiction in which I'm personally licensed. I'm licensed in Florida. I'm licensed in the District of Columbia. What if the District of Columbia lawyer, under the DC Rules of Professional Conduct, has information that will prevent serious bodily crime? There, the DC rules say may. The District of Columbia lawyer may reveal that confidential information under Rule 1.6 sub C sub 1 of the DC Rules of Professional Conduct. What about in the District of Columbia under the DC Bar Rules? A DC lawyer who has information that would prevent a non-bodily crime. There, DC Rule 1.6 says that the District of Columbia lawyer shall not reveal the confidential information, even though it would prevent a non-bodily crime. It remains confidential. It cannot be disclosed by the member of the District of Columbia Bar. What if the member of the District of Columbia Bar has confidential information, but revealing it would prevent a non-criminal fraud? Again, a type of fraud that doesn't sink to the level of criminal conduct, but is a civil wrong, violates the civil law, is a fraud under the civil law. What if that civil law violation and the harm that would arise can be avoided simply by the member of the DC Bar revealing his own client's confidential information? Sorry, but the District of Columbia Rules of Professional Conduct say that the DC Bar member must not reveal the client's confidential information, even if doing so would prevent a non-criminal fraud. What if the member of the District of Columbia Bar's services were used in the past, and they were used in the past to commit a crime or a fraud? To rectify that, may a member of the District of Columbia Bar reveal a client's confidential information? Rule 1.6 of the DC rules say no. Rule 1.6 say that the member of the DC Bar must not reveal confidential information, even to rectify a past crime or fraud where the lawyer's services were used to commit that past crime or fraud. Here's a tricky one. It talks about fraud on the court. When fraud on the court is present or is substantially certain to happen in the future, the member of the District of Columbia Bar may not participate directly in client perjury. And of course, that's true of the Florida lawyer too. But turning back to the member of the District of Columbia Bar, when fraud on the court has already happened in the past, the member of the District of Columbia Bar may not reveal confidential information. So if the fraud on the court has already happened, the DC bar member must not reveal confidential information, even to help rectify the effects of that past fraud upon the court. That's the opposite of the Florida lawyer, who must disclose under Florida Bar Rule 4-3.3 sub A sub 2. So imagine yourself, if you're not already a lawyer, being like many of us, being licensed in more than one jurisdiction. I, for example, am licensed in both Florida and DC, but my obligations as to confidential information will vary based upon which one of those rules apply, the rules regulating the Florida bar or the DC rules of professional conduct. So this is an example of how the model rules are just that. They're just hypothetical. They're just a group of scholars and practicing attorneys who got together and came up with their opinion of what the rules should be. But that's not binding upon anyone anywhere. What's binding upon us as licensed lawyers are the rules that regulate us in our particular jurisdiction. We've got to know them. We've got to have a place to reliably get that kind of information. That's why I'm thankful that the Florida Bar, for example, will take a phone call. We have a Florida Bar Ethics Hotline. It's not open to everyone. It's only open to members of the Florida Bar. And even for members of the Florida Bar Ethics Hotline is not open for every scenario. If you've already taken the action, you can't call and get an opinion from the Florida Bar Ethics Hotline. You've got to be a member of the Florida Bar calling about your own personal future contemplated conduct. And then you can call the Florida Bar Ethics Hotline and get their opinion on the matter. Another way to get an opinion in that scenario, or in almost any other scenario, including those not covered by the Florida Bar Ethics Hotline, is to call your friendly neighborhood bar grievance defense attorney. Someone like me, who's proud to defend his fellow members of the Florida Bar, District of Columbia Bar against bar grievance ethics complaints, or any other scenario where you need advice about what your obligations are when it comes to your professional conduct. So keep in mind, under the model rules and under almost any jurisdiction's rules, certainly under Florida's rules, under the District of Columbia's rules, one of the things that is an exception to client confidentiality is talking to me, your friendly neighborhood bar grievance defense attorney, about your own past, present, or future conduct. You can share with me as your lawyer, as your friendly neighborhood bar grievance defense attorney, the confidences of your client, and it's not a violation of your duties of confidentiality. And those confidences, once shared with me, become part of my duty of confidentiality. I keep those confidences confidential too. But you can share them with me because you're asking me about how to properly interpret your ethical obligations to your own client. So it is impliedly authorized by the fact that your client hired you as their lawyer. They have impliedly authorized you to share with me in confidence, and then for me to also keep in confidence, your client's confidences, so that you can give them thorough, professional, and appropriate representation that is in compliance with your bar rules. That sharing of information for that limited purpose of getting my advice as your friendly neighborhood bar grievance defense attorney, or friendly neighborhood ethics advisor, or friendly neighborhood compliance officer, all of that is impliedly authorized by the fact that you've been hired to be a lawyer who is ethical and diligent and zealous for that client. Also, if for whatever reason it became a scenario where there's a claim against you arising out of your representation of that client, and now that client is making a claim against you, you can use confidential information to defend yourself, information that was confidential and shared by the client that is now bringing the claim against you. That is a reflection of the common law, which held that those with the fiduciary duty, which of course lawyers have to a client to a great extent, the common law said that those with the fiduciary duty are not hamstrung and tied up by that fiduciary duty to their own detriment when the fiduciary is trying to use the fiduciary duty against you. So just as the common law said that, so too do the model rules say, and so too do the rules of almost every jurisdiction, Florida and DC included, say that if the client has brought a bar grievance or ethics complaint against you based on your representation of the client, that's a permissible time to use the confidential information learned in that representation for your own defense. You don't disseminate it any broader than you have to for your own defense. You don't start running billboards or putting up websites or slandering your client's name all over town. No. But in an appropriate way, such as asserting defenses to the bar complaint. Now you have permission to use the confidential information learned in the representation of that client in order to defend yourself appropriately from the complaints of that same client. So that's part of the model rules, and that's part of the rules regulating the Florida bar and the DC rules, and almost everywhere is part of the rules of that jurisdiction. But now, when it comes to some examples, our textbook gave us some beautiful examples to explore when it comes to confidential information and how do those confidential rules apply. Let's read a little bit closer from our required reading. Take a look at those. One of those examples the textbook gave us was what the textbook called smoking guns. Very figurative language there. But smoking gun evidence. The textbook tells us, look, don't touch. Look, don't touch. Textbook cites to Model Rule 3.4, but it's also an implementation of Model Rule 1.6. Rule 3.4, the textbook reminds us, says that we got to be fair dealing with the opposing party. And of course, that's true because Model Rule 1.4 says we can't alter evidence. We can't spoliate evidence. We can't ruin the evidence. We can't deliberately do those things. We have to affirmatively try to prevent our clients from doing those things. So if there's smoking gun evidence, our textbook says, in order to comply with those 3.4 obligations and to still keep that evidence confidential, we should look but don't touch, which is a reference to the fact that if the evidence comes into our possession, now under the model rules and under the rules of most jurisdictions, that evidence is going to be subject to discovery in an adversarial context by the other side. So that's why our textbook says for this smoking gun kind of evidence, look but don't touch. That's what the textbook was talking about there. To quote the textbook directly, let me read this sentence, or two sentences. The protection of attorney-client confidences ceases when tangible evidence is in the possession of the attorney or when the attorney interferes with material evidence. If the attorney does not possess the item of evidence or interfere with it, he or she is precluded from revealing any information about it. So you see how the textbook is giving us an example of combining the duty of confidentiality that we find in places such as Model Rule 1.6, combining that with our duties to the tribunal and the adversarial system, such as we find in Model Rule 3.4, to create what the textbook is referred to as their look, don't touch rule. I thought that was an interesting part of the textbook. It's certainly worth further analysis by you. Go ahead and dive into that. So now we know about a duty of confidentiality. What is it that's confidential? What's confidential? Well, most broadly stated, if it's knowledge that you obtained in the course of representing a client, then that's confidential information. Here's where that gets a little tough. Sometimes you learn some things that were otherwise known by others, but you learned them by representing the client. Turn to the rules of your jurisdiction. The majority rule is that that information becomes confidential. Yeah, other people know about it. Yeah, other people are talking about it. You hear them, you see them, but you don't engage in that conversation. You don't talk about it. You don't tell others about it. Because even though they know it, the majority rule is that you are obliged to keep the confidence. So, what about information that was publicly known to others, including you, and also is information obtained by representing the client? Again, turn to the rules of your jurisdiction. But you might just find that even though everybody else knows about it and you knew about it before representation, nevertheless, you might still find that now you're obliged to keep the information confidential. So, now let's take a look, a deeper look, a closer dive into the particular case law precedent cited in Chapter 17 of your required reading on the syllabus. Specifically, let's take a closer look at the case. Can you see it there? See it? At the case of Swindler and Berlin versus United States. This is a case that comes from the Supreme Court of the United States, issued in the year 1998, found, if you will, in places such as 524 U.S. 399, and widely available on the internet in many other places for free and in many of the subscription databases. So, what is going on in this case? And this case is answering a question about confidentiality. Specifically, does it end with the end of the life of the client from whom the confidential information was obtained? That's right. Does confidentiality end at the end of your client's life? That's the question here. This was a decision from 1998 and was part of litigation involving a special counsel. Now, there was a time where the President of the United States was being investigated by a special counsel. This particular President of the United States, William Jefferson Clinton, was a licensed lawyer, and I emphasize the verb was. Today, William Jefferson Clinton is disbarred. The behavior involved special counsel because there were accusations of criminal activity. There were also facts involved in the 1990s involving William Jefferson Clinton, which were more than accusations. Indeed, there were facts that were not disputed, facts that are hard to believe by today's standards. And I find it hard to even try to draw a line between the standards of the 1990s and today. But one of the beautiful things about our great nation is that she is always on the path of self-improvement. The United States of America and the beautiful American people are never shying away from self-improvement. And that's certainly true when we look at some of the undisputed facts that underline Swindler in Berlin versus United States and involve the presidency of William Jefferson Clinton. The undisputed facts to which I refer are facts that anyone in the modern era, as I speak to you today, will undoubtedly agree were disgusting, were despicable, should never have occurred in any workplace, anywhere, especially not the highest workplace in the land, the White House, the Oval Office. The undisputed facts involved things that can only be called sexual harassment by a supervisor. It saddens anyone to look back and say that the President of the United States, William Jefferson Clinton, in his role as a supervisor and as an employer, engaged in this despicable, disgusting, inexcusable, and unforgivable behavior in the workplace. And we all know what we're talking about. We talk about one of the interns there. And to be an intern in the White House means to maybe work for pay, maybe not, but certainly to work in the hope of a letter of recommendation from the President of the United States. Behavior that might have even been consensual. Behavior like that William Jefferson Clinton inflicted upon intern Monica Lewinsky is inexcusable behavior in that circumstance, in the circumstance where the balance of power is so lopsided, where the hope of a discretionary letter of recommendation is so hoped for, that things that aren't quote unquote required to be done for the chief executive to even be impliedly asked for, to even be vaguely suggested, the imbalance of power makes it too great that this kind of behavior simply can't be tolerated. We know from the DNA evidence that the president's DNA was found on Monica Lewinsky's blue dress. So we can't reasonably doubt the testimony of fellatio underneath the president's desk in the workplace of, God, it makes me almost tremble wanting to say it, the insertion of a cigar by the President of the United States into an intern. There isn't a workplace anywhere where anyone should be asked to do such things, especially not in such an imbalance of power where the holder of the office of the President of the United States, who's quite routinely and quite commonly referred to as the most powerful man in the free world, this can't happen. What happened involving William Jefferson Clinton and Monica Lewinsky. I'm not faulting Monica Lewinsky in any way, shape, or form. I am putting 100% of the blame upon William Jefferson Clinton. Maybe this wasn't the specific and direct reason that this former lawyer, William Jefferson Clinton, is now a disbarred attorney, but thank God that person is disbarred. And as we look back at the behavior of William Jefferson Clinton, all we can ask is, how on earth did anyone defend against this person's removal from this position of power, knowing the undisputed facts were that William Jefferson Clinton engaged in this atrocious, disgusting, inexcusable, and indefensible behavior in the workplace? And if there is an answer to that, maybe it's because America is a better place now. Clearly, if what William Jefferson Clinton did then was done now, no matter what office that person held, that person is out and has to be out. But William Jefferson Clinton was not out, and maybe we'll never know how many more victims William Jefferson Clinton has. Maybe some people are just too powerful in the 1990s to be subject to the necessary laws of our nation. And that's the background of this 1990s decision of Swindler and Berlin versus United States. It involves William Jefferson Clinton. It involves special counsel that's been appointed, Kenneth Starr, who's on the brief in this case. And it involves the Brett Kavanaugh, who then was an attorney working for special counsel Kenneth Starr, doing good and honorable and thorough work, including a great job on this particular case. Ultimately, the majority didn't agree with Brett Kavanaugh, but when you hear the arguments Brett Kavanaugh made, they were strong, they were brilliant, they were thorough, and they were well supported by the law at that time. So Brett Kavanaugh argued the case for special counsel for the United States. On the brief with Brett Kavanaugh was Kenneth Starr. And Chief Justice Rehnquist delivered the opinion of the court, the majority opinion. But when we're done talking about the majority opinion, we will not neglect a beautifully written dissent by Justice Sandra Day O'Connor, which was signed on to by two of my heroes, and probably yours, Justice Scalia and Justice Thomas. They signed on to Sandra Day O'Connor's dissent. So let's take a look at the facts of this case. The petitioner is an attorney named James Hamilton, and it appears from the facts of this case that James Hamilton was an attorney of the firm referred to as Swindler in Berlin. Now, it involved William Foster. William Foster was working for the White House Travel Office and working for the administration of William Jefferson Clinton, who was President of the United States at that time, and who at that time had a license to practice law. Now he's disbarred, of course. But William Jefferson Clinton at the time had a license to practice law, and at the time was in the White House. Vincent W. Foster Jr. was Deputy White House Counsel. I'm sorry, I misspoke when I said that he worked at the White House Travel Office. William Foster was Deputy White House Counsel at the time that there were firings at the White House Travel Office. The Office of the Independent Counsel at the time of Swindler in Berlin versus United States is conducting an investigation into whether various individuals made false statements, whether various individuals obstructed justice, or whether various individuals committed other crimes during the independent counsel's investigations of the 1993 dismissal of employees from the White House Travel Office. Now, Vincent Foster is Deputy White House Counsel at the time that those firings occurred. Vince Foster meets with the petitioner, James Hamilton, an attorney of Swindler in Berlin, in the month of July 1993. The reason attorney Vince Foster is meeting with attorney James Hamilton is because Vince Foster wants to be represented. Vince Foster is a lawyer thinking of hiring a lawyer. Vince Foster is seeking representation concerning possible congressional or other investigations of the firings. There's a meeting about 2 hours long, according to these facts, between Vince Foster as potential client and James Hamilton as potential lawyer to potentially represent James Foster. Attorney James Hamilton is taking some handwritten notes at this meeting. Fortuitously, perhaps, fortuitously from the perspective of James Hamilton and James Hamilton asserting confidentiality, fortuitously, James Hamilton, one of his first entries in the notes is the word privileged. These handwritten notes reflect what Vince Foster said while meeting with James Hamilton and Foster considering hiring as Foster's attorney and Hamilton considering accepting the potential hire by Foster as Hamilton's lawyer for Foster. 9 days after this meeting, Vince Foster commits suicide. That was in approximately July of 1993. Later in December of 1995, the independent counsel has convened a federal grand jury. In that context, the Office of Independent Counsel has issued subpoenas, including subpoenas to Hamilton, that's attorney James Hamilton, and to his firm, Swindler in Berlin, seeking, among other things, attorney Hamilton's handwritten notes from the July 1993 2-hour meeting between attorney Hamilton and Vince Foster. Hamilton, along with Swindler and Berlin, file a motion to quash the subpoena. Attorney Hamilton and his firm are arguing that the notes are protected by the attorney-client privilege and by the work product privilege. In other words, they're asserting confidentiality because they learned the information reflected in the notes in the course of representation. But their client, Vince Foster, or potential client, Vince Foster, is no longer with us. By that point, Vince Foster has passed away. The district court reviews the notes in camera, by which we mean the Latin phrase to mean that the district court has, on its own and without sharing with others, the presiding judge alone has looked at those notes, read them over. Opposing counsel didn't get to see him. Nobody else got to see him. Just the presiding judge in secret, all by her himself, has looked at the notes and concluded that they are indeed confidential, that they are protected from disclosure by both the attorney-client privilege and the work product privilege. So the presiding judge has denied enforcement of the subpoenas. An appeal happens. Court of Appeals for the District of Columbia Circuit, which at this time, Brett Kavanaugh is not yet a judge. Remember, Brett Kavanaugh is arguing the case before SCOTUS. He's on the brief. He's doing the argument. And the reason I point that out is because he's not on the DC Circuit either at this time. Okay. So the Court of Appeals of the District of Columbia Circuit, they reverse. They recognize that most courts assume the privilege survives death. But there aren't a plethora of actual holdings that say the privilege survives death. Indeed, most of the cases simply presume that the privilege survives death. And they presume in the context of ruling upon an exception to confidentiality. Specifically, one of the exceptions is that communications are privileged during a testator, someone who's signing a will, someone who's leaving a last will and testament. Communications are privileged during the testator's lifetime and remain privileged after the testator's death unless sought to be disclosed in litigation between the testator's heirs. So what the lower court, not much lower than SCOTUS, but at least in this context, the lower court is the Court of Appeals for the District of Columbia Circuit. That lower court is noting that most of the case law is ruling upon whether this exception applies, the exception for litigation between the testator's heirs, and is simply glossing over, simply mentioning in dicta, is not actually ever specifically holding that there is an exception, that there is a confidentiality that survives the client. Let me rephrase, try to be a little more clear. There's lots of case law out there ruling on whether we should apply the exception for litigation between the testator's heirs. And in so ruling, those cases are presuming this information is confidential, but these cases are never actually stopping to specifically rule that there was confidentiality in the first place. You see Brett Kavanaugh's brilliant observation and brilliant argument here? And he's right. It's dicta, right? Well, we can argue, well, we should consider it to be more than dicta because they moved past it and they were trying to determine whether or not the exception applied. But it's still technically true that it's dicta because it wasn't the ruling of these cases, right? If these cases jump ahead to rule on the exception without first stopping and ruling that it's confidential, they're just presuming it's confidential. See what a brilliant lawyer we've got there? Brilliant lawyering. So, and it's not a false statement. It's not a frivolous claim. It's absolutely true that they aren't glossing over that. It is dicta. It's not the holding of these cases. So it does remain an open question for SCOTUS to resolve. Does the passing of one's client end the duty of confidentiality? That's what this case decides. And this case, the 1998 Supreme Court of the United States decision of Swindler and Berlin versus the United States holds that the duty of confidentiality lives on even after the passing away, the death of the lawyer's client. The death of the lawyer's client is not the death of the confidentiality. The duty of confidentiality remains. The information remains confidential even after the client dies. That's the holding of Swindler and Berlin versus United States. How did they get there? Well, first, they had to agree. Attorney Kavanaugh, future Justice Kavanaugh, Attorney Kavanaugh was correct. There wasn't firm case law precedent that bound and said that the confidentiality survived the death of the client. But folks wrote books, like I like to do, like my books back here. Wrote that one. Yeah. I wrote that one. Wrote that one. There you go. I wrote that one. That one there. I co-wrote that one. My name's on the bottom there. So there were commentators who wrote books, for whatever that's worth, and opined that the duty of confidentiality survived death. So the opinion reads, commentators on the law also recognize that the general rule is that the attorney-client privilege continues after death. Commentators on the law. Any Joe Schmo can be a commentator on the law. Look at me. I've certainly commented on a few laws, right? What's that mean? That's not binding precedent. It's not binding on anyone. Commentators on the law express opinions. Opinions are like noses. Everybody has one, right? But that's the first part of their opinion. Commentators on the law recognize that the general rule is that the attorney-client privilege continues after death. But they also had to acknowledge, because Brett Kavanaugh is wise enough to point it out, quote, undoubtedly, as the independent counsel emphasizes, various commentators have criticized this rule, urging that the privilege should not be abrogated after the client's death. I'm sorry, I misread that. I should not be abrogated. It reads should be abrogated. Let me start over so I get it right. Undoubtedly, as the independent counsel emphasizes, various commentators have criticized this rule, urging that the privilege should be abrogated after the client's death, where extreme injustice would result, so long as disclosure would not seriously undermine the privilege by deterring client communications. Those commentators were acknowledging that we do need an attorney-client work product and confidentiality rules in order to encourage client communication to be adequate enough for the client to get correct legal advice and diligent and zealous representation. But those commentators said if we can avoid undermining that privilege and at the same time avoid an extreme injustice, then that should be an exception. So the commentators were arguing for the same exception that future Justice current Attorney Kavanaugh is arguing for in this case. Despite the scholarly criticism, holds the majority opinion, we think there are weighty reasons that counsel in favor of posthumous application. The majority opinion goes on. Knowing that communications will remain confidential even after death encourages the client to communicate fully and frankly with counsel, says the opinion. And then the opinion cites to nothing. No citation there. No case law precedent cited. No commentators expressing their opinions cited. No surveys cited. No statistics cited. Nothing cited. How do we know that to be true? The opinion goes on, again without any citation. While the fear of disclosure and the consequent withholding of information from counsel may be reduced if disclosure is limited to posthumous disclosure in a criminal context, it seems unreasonable to assume that it vanishes altogether. Again, citing to nothing. And saying that it seems unreasonable. Seems that way, huh? Got nothing to cite to, huh? Okay. Opinion goes on. Clients may be concerned about reputation, civil liability, or possible harm to friends or family. Posthumous disclosure of such communications may be as feared as disclosure during the client's lifetime period. Again, cites to nothing. No case law precedent, no surveys, no expert testimony, no witness testimony, nothing. The opinion then goes on. The contention that the attorney is being required to disclose only what the client could have been required to disclose is at odds with the basis for the privilege, even during the client's lifetime. In related cases, we have said that the loss of evidence admittedly caused by the privilege is justified in part by the fact that without the privilege, the client may not have made such communications in the first place. This is true of disclosure before and after the client's death, Without assurance of the privilege's posthumous application, the client may very well not have made the disclosures to his attorney at all. So the loss of evidence is more apparent than real. In the case at hand, it seems quite plausible that Foster, perhaps already contemplating suicide, may not have sought legal advice from Hamilton if he had not been assured the conversation was privileged. And all of this is verbatim from the court's opinion, not mine. All of this is their presupposition, is it not? All of this is a pyramid of inferences, is it not? All of this is presuming this, and then based on that presumption, presuming that, and then based on this presumption, presuming that, and then based on this presumption, presuming that. And I think even the court itself would be forced to admit that, because I'm looking for the specific language here where the majority opinion says that this would be an area where some statistics, some surveys, some evidence would be helpful, but it doesn't exist. Let me find that particular. Yeah, here it is. No, that's not it. It criticizes the independent counsel and says the independent counsel has simply not made a sufficient showing to overturn the common law rule embodied in the prevailing case law. But in another piece of sentence here, forgive the pause, but I really want to find this sentence, which I wish I'd underlined, so I wouldn't have to pause. Bear with me. Sorry for the pause. I found the language I was thinking of. Let me read it to you, and then we'll discuss it. From the majority opinion, quote, while the arguments against the survival of the privilege are by no means frivolous, they are based in large part on speculation, thoughtful speculation, but speculation nonetheless, as to whether posthumous termination of the privilege would diminish a client's willingness to confide in an attorney. In an area where empirical information would be useful, it is scant and inconclusive. So there, in that language, the majority opinion is acknowledging that these suppositions, either for or against the privilege surviving despite the death of the client, these suppositions about what chilling effect or what effect at all it would have upon a live client's willingness to share confidential information in confidence with that client's own attorney, there just isn't empirical information that tells us one way or another whether the client would be less willing to share confidences if the client's own death would mark the end of the duty of confidentiality. So I think the majority, at least in that part that I struggled so hard to find and then finally found and read to you, is acknowledging that either argument is based on some suppositions based on some inferences is a pyramiding of inferences, is supposition upon supposition upon supposition to come to an outcome. And I think a fair criticism of the majority's opinion is right there in that quoted sentence from the majority's opinion. But as I promised, there was a dissent that we will discuss. It was written, as mentioned, by Justice Sandra Day O'Connor. Justice Antonin Scalia also signed off on it. Justice Thomas also signed off on it. The dissent begins. Although the attorney-client privilege ordinarily will survive the death of the client, I do not agree with the court that it inevitably precludes disclosure of a deceased client's communications in criminal proceedings. Look at that. In my view, says the dissent, the criminal defendant's right to exculpatory evidence or a compelling law enforcement need for enforcement may, where the testimony is not available from other sources, override a client's posthumous interest in confidentiality. That's not the law. That's not true. That's the dissenting opinion. But isn't that a powerful dissenting opinion? To see the power in it, I draw your attention to the dissent's quote from Muller and Kilpatrick, Federal Evidence, Section 199, page 380, second edition, 1994, where they quote that treatise as saying the following, quote, if a deceased client has confessed to criminal acts that are later charged to another, surely the latter's need for evidence sometimes outweighs the interest in preserving the confidences. End. Think about that. Muller and Kilpatrick in their 1994 Federal Evidence Treatise is saying that if you had a client and now they're dead, and the confidential information you learned from the now dead client was that the now dead client was the one that committed the crime, but some innocent person is now going to jail for that crime, then you as the lawyer should be able to share the dead man's confession in order to prevent the innocent man from rotting away in jail. That's what Muller and Kilpatrick in their 1994 treatise was suggesting. That's what Justice O'Connor, with agreement of Justice Scalia and Justice Thomas, were suggesting. That's what the law is not. That is an erroneous statement of the law. That's not an exception to confidentiality, according to Swindler and Berlin versus United States. According to Swindler and Berlin versus United States, if you're a lawyer who knows that your dead client, who obviously can't go to jail now, your client's dead. If your dead client is the real criminal, but some innocent person is rotting away in jail for a crime they didn't commit because your dead client committed it, according to Swindler in the United States, you, the lawyer, have to shut up. You, the lawyer, are forbidden from sharing that information. You, the lawyer, have to somehow live with yourself, knowing that because you're keeping the confidences of a dead criminal, a live, innocent person is rotting away in jail for a crime they did not commit. In Swindler and Berlin versus United States, then attorney and now Justice Kavanaugh was trying to prevent you and I from having to live with the situation like that. And there was no binding case law precedent that required you and I as licensed attorneys to live with a situation like that. No binding case law precedent required society to have to endure a situation where innocent people are rotting away in jail for crimes they didn't commit and could be out if a lawyer could simply share the confidences of a dead criminal who no longer has any benefit from those confidentiality proceedings remaining confidential. And society has every benefit from an innocent person being freed from being jailed for a crime they didn't commit. But no, no, no. They rot in jail. So that lawyer, in his heart and soul, can continue to rot away knowing that they're rotting in jail because the lawyer can't share that confidence because of holdings like Swindler and Berlin versus United States. It's a shame the special counsel's office does this one. It's a shame that the correct arguments of then attorney and now Supreme Court Justice himself, Brett Kavanaugh, were not accepted. It's a shame that the dissent of Justices O'Connor, Scalia, and Thomas was not accepted because now our profession is worse off for it because now the potential for innocent people remaining in jail for crimes they didn't commit has increased. But that's just my opinion. I'm just a commentator who writes opinions. Opinions are like noses. Everybody has one. What's your opinion? What do you think? Should innocent people have to stay in jail because our profession is obliged to keep the confidences of dead criminals? How would you like to be the lawyer who's standing in the way of an innocent person being freed from jail because you have a professional obligation to keep a dead criminal's secrets secret? Opinions are like noses. What's your opinion? It's time for another 10-minute break. I'll see you in 10 minutes, and we'll continue our lecture then. I guess I'm back from the 10-minute break, maybe a minute or two early. Perhaps that'll make up from the fact that our first break lasted a minute or a minute and a half too long. Maybe in the end it all evens out. But if you're just joining us, welcome back. We are wrapping up our discussion of the duty of confidentiality. I emphasized its strengths, and more often than not, I emphasized its weaknesses. And I think I may have illustrated that it is a true burden upon the attorney, and a burden that the attorney must bear to be in this great profession of ours. With great power comes great responsibility, said the Son of Man and the uncle of Spider-Man. And no matter where you find the source of that truth, I think you can agree that it's true. Okay, so now that certainly covers chapter 17 of our required reading. Before we end our day, let's not neglect chapter 18, which talks about zealous representation, and chapter 19, which talks about candor to the tribunal. Both of those are responsibilities that we have as lawyers. Must they conflict? Well, let's break them down one by one before we get to the final answer of that ultimate question. Let's look first at zealous representation. We know that the concepts expressed in Model Rule 1.3 are adopted and true everywhere. They say that claims must be meritorious. We can't bring a frivolous claim. That is a breach of our professional responsibility. We can't rest on a frivolous defense. That is a breach of our professional responsibility. In the criminal law context, these responsibilities do not mean that we fail to hold the criminal prosecutor to their burden of proof on all elements of the crime. All elements of the crime must be proven beyond a reasonable doubt by the criminal law prosecutor. It is not the obligation of the criminal defense attorney to concede to any of the elements of the crime. And that's true despite the professional responsibility of neither bringing a frivolous claim nor defending based on a frivolous claim. Rights to counsel, constitutional rights, the Sixth Amendment to the United States Constitution, and the fact that the criminal law burden is one of beyond a reasonable doubt, all combine to mean that the criminal defense attorney can hold the prosecutor's feet to the fire and require the prosecutor to prove every element of the crime beyond a reasonable doubt. That's true for the criminal defense attorney, but not so true for the civil law defense attorney in a civil matter. You can't simply bring a frivolous defense and claim that you haven't breached your duties of professionalism simply because you're on the defense side. It doesn't work that way. Both on the plaintiff side in bringing claims and on the civil defense side. In the civil defense of a civil claim, we can't bring a claim or defense that is frivolous. So there'll be times when the civil defense attorney must concede where the criminal defense attorney must not. And that's a difference that is based upon whether the claim is one of a crime, whether the punishment results in the loss of freedom instead of money. We draw the line there. Chapter 18 of our text reminds us that lawyers have to have a purpose other than harassment, unnecessary delay, or placing a burden upon a third party. These are impermissible primary goals for our actions under the rules of professionalism that bind us as attorneys. Our profession is better than that. The textbook in chapter 18 also talks about that inadvertent disclosure. Don't forget, when we talked about confidentiality 1.6, we did mention that closing paragraph that told us, and I quote from the model rule, a lawyer shall make reasonable effort to prevent the inadvertent or unauthorized disclosure of confidential information. What if you made those reasonable efforts, but you goofed? You hit send on an email with the wrong attachment. You hit reply all to an email where you really should have just hit reply. What if it's your best efforts, but it was inadvertent? Well, under the rules of the majority of jurisdictions, we place a burden upon the attorney recipient. Yeah, the attorney who gets the inadvertent disclosure. And we say that if that recipient lawyer knew or should have known in some of these rules, knew or should have known that this was an inadvertent disclosure, you got to tell the sender right away, and you got to ignore it. You got to not open it. You got to not read it. Got to not share it with your client. This is how inadvertent disclosure has been addressed in many jurisdictions. Indeed, these concepts are found in the model rules, in Model Rule 4.4, subsection B. Now, what about a claim to change the law? A lawyer is allowed to make a good faith argument for a change, extension, or modification in the existing law. We do not consider such a claim to be a frivolous one. But in best practices, I would warn you of this. In order to best protect yourself as the lawyer who's making the claim for a good faith argument for a change, modification, or extension of the existing law, I would recommend getting that on the record, conveying that information to the presiding judge or tribunal, even sharing that information with opposing counsel so that it's on the record and it's clear that that's what you're up to, so that you don't find yourself in a situation later where you're being accused of making that up and using that as an excuse because you were busted on a frivolous claim. Here's what I mean by that. So say you know that the law is adverse. I recommend at best practices, if you know the law is adverse and your goal is a good faith argument for a change, extension, or modification of that law, to present it as such, to say that. Your Honor, in my good faith argument for a change, extension, or modification of the law, where the law has been interpreted to say this, I am arguing for this, and here's why. You're better off doing that up front than simply making the argument later and then having opposing counsel say, hey, that's not what the law says, and then you respond, well, I'm making a good faith argument for the change of an existing law or modification of that existing law, and then opposing counsel responds with, now that he's busted, that's what he's saying. You don't want to be in that situation. Are you required to preface? Well, maybe not, but best practices would certainly indicate that you should preface your argument for a change, modification, or extension of existing law, to preface it and announce that that's what you're up to. The textbook talks about Federal Rule of Civil Procedure Rule 11. Rule 11 means money out of your wallet. Rule 11 means the presiding federal judge can open your wallet and sanction you to pay money by way of attorney fees. So You don't want a claim to sink to the level of frivolous, not only because that's unprofessional, not only because that violates the rules of our profession and the rules of professionalism, but also because it violates Rule 11 of the Federal Civil Procedures and can result in you paying money. Maybe your state has something equivalent to Rule 11. For us Florida lawyers, we have Florida statutes 57.105. 57.105 can result in very similar results to Rule 11, where the lawyer pays attorney fees personally as a sanction. So check the rules of your jurisdiction. It may be in the rules of professionalism. It may be in the statutes. In Florida, if you're in front of the Division of Administrative Hearings, you can find the Florida Administrative Code has some rules that might result in a similar outcome to Federal Rule of Civil Procedure Rule 11. For example, before a Florida Division of Administrative Hearings, Office of the Judges of Compensation Claims, you might find yourself sanctioned under Florida Administrative Code, Chapter 60Q-6. There are subsections within Chapter 60Q-6 that look a lot like Rule 11. So don't try to relax if you're not in federal court. Don't try to relax if you're not in state court, even in a state administrative tribunal. You can find yourself with financial sanctions in certain circumstances. So when it comes to frivolous claims, just don't do it. As the criminal defense attorney, you might have an obligation to hold the prosecutor's feet to the fire and compel the prosecutor to meet the prosecutor's burden to prove every element of the criminal defense beyond a reasonable doubt. But other than that circumstance, if it's frivolous, whether it's a claim or it's a defense, don't do it. Our profession is better than that. Fairness to an opposing party is covered in subsection D of Chapter 18 of our required readings. And we already talked about how Model Rule 3.4 and the concepts embodied there mean that the lawyer doesn't engage in spoliation of the evidence. The lawyer works to try to prevent his client from spoliating evidence. The lawyer doesn't modify or destroy evidence. We don't take a hard drive and smash it and acid bleach it after the FBI wants to see our emails. I know there are those in the public eye who've done that and apparently have gotten away with it, but we're better than that. We as licensed lawyers don't do that. That is a violation of the rules of our profession, if not a violation of statutes and court rules. Don't spoliate and destroy evidence. Don't be a part of it. Don't encourage your clients to do it. Do everything you can to prevent your clients from doing it. So a lawyer, they can't obstruct another party's access to evidence, but lawyers may ask their clients, employees, or relatives to refrain from giving relevant information to another party in a currently litigated case. That's okay. But that's an exception to the rule. So if you're going to do that, make sure you meet that exception on all fours. Can't tell a client to perjure themselves. You can't tell a client to testify to a lie. You can't offer a witness who you know is going to lie. You can't offer perjured testimony. Rule 3.3 of the model rules suggests that you gotta rectify perjury that's happening in a pending case. Check with the rules of your particular jurisdiction to see whether or not that concept is embodied within the particular rules that bind you as a member of that state bar. Now, what about dealing with the third party? The golden rule tells us that we always deal fairly with others. And of course, that's true of lawyers too. What about negotiations? Is a lawyer not allowed to bluff in a negotiation? Is a lawyer not allowed to embellish and do some puffery in the course of a negotiation? A lawyer is allowed, within the bounds of fairness, within a negotiation, done at arm's length with a third party who is aware that we don't represent them, who is aware that we are not their fiduciary. We are allowed to negotiate in a fair way, which in certain circumstances may involve a bit of puffery. But it has to be a context where the lawyer is not giving testimony. Has to be a context where a lawyer is not under oath. Has to be a context where everyone understands it's a negotiation. We have duties to third parties. Rule 3.3 of the model rules embody many of those duties to a third party. And we've got to deal with them in fairness. Obviously, we can't be complicit in a crime or a fraud. And that's true even in an arm's length negotiation. The fact that we are negotiating on behalf of a client is not a license or permission to engage in fraud or a crime or a tort. So don't do it. A lawyer can't assist a client in an illegal act. You're going to find that concept embodied in Model Rule 1.2, such as subsection D. You're going to find that concept embodied in Model Rule 3.3, such as its subsection B. You're going to find that rule embodied in every jurisdiction's rules of professional conduct, and you're going to find that rule embodied in the relevant criminal law. So don't do it. Don't forget Model Rule 8.4. 8.4 in some shape or form exists within the concepts of all rules of professional conduct in all jurisdictions. And it helps bar counsel to bring in and make actionable as a source of discipline of lawyers certain conduct that isn't spelled out on all fours in some of the rules. I've criticized Model Rule 8.4 as being vague. Perhaps there are times where it might even be void for vagueness, either on its face or as applied to a particular circumstance. But unless and until it's been found in your particular jurisdiction, keep in mind that 8.4, however it's been enacted in your particular jurisdiction, is going to allow bar counsel to bring an ethics complaint and a grievance against you for something that isn't exactly on all fours spelled out as wrongful within your particular jurisdiction's rules. It's a catch-all of sorts. If you're following the golden rule, you might not have to worry about the vagueness of 8.4, perhaps. But watch out that it meets the test of morality. If you're acting immoral, more likely than not, you're violating the rules of our profession, especially in a jurisdiction where a vague and broad Rule 8.4 has been enacted. So watch out. Do the right thing. Follow the golden rule. The textbook points out that fraud not during the course of representation must be kept confidential, and we talked about that earlier. The textbook addresses, in subsection K, threatening criminal charges. I would summarize that section as follows. Don't threaten, just do it. Don't threaten criminal charges. Just bring the criminal charges. Why do we do that? Well, whether you're negotiating with an opposing counsel or you're sending a demand letter, you're firing off an angry email. Try not to fire off angry emails. Most of those you're going to regret later. But if you threaten to bring criminal charges, that's a violation of the rules of professional conduct. If you simply file a criminal charge, in most jurisdictions, that's not a violation, assuming you had a good faith basis to believe that it was appropriate to bring the criminal charge. So that's why I say the way to summarize Section K that talks about how it's wrongful to threaten criminal charges to gain advantage in a civil case, that's why I would say, to summarize that section, don't threaten, just do it. If opposing counsel, opposing party really did commit a crime, then go report the crime and move on. Don't try to use it to gain advantage in your civil case. That's a violation. Trying to use it as an advantage is a violation of the rules of professionalism. So don't threaten, just do it. The textbook, however, does talk about ABA Formal Opinion 92-363, which was issued in 1992, that might contradict my opinion about don't threaten, just do it. Yeah, hey, it's just an opinion. Opinions are like noses. Everybody has one. If you're interested, go ahead and pull ABA Formal Opinion 92-363 if you can afford it. And I mean that literally. Our good friends at the American Bar Association, they want you to buy their ethics advice. They want you to buy their formal opinions. I'll reserve for another day a discussion about whether it's ethical to put ethics opinions behind a paywall. If you're a group like the ABA, I'll reserve my opinion on that for a later time. And then this chapter 18, lesson 18, ends with subsection L, the topic of which is being involved in a transaction with third parties and persons that are not your client. So one thing you got to remember is if they're represented, you don't communicate directly with them. You find that concept embodied in Model Rule 4.2, and you find it embodied in every jurisdiction's binding rules of professional conduct. If you know that an individual has a lawyer, that they're represented by a lawyer, that's when you stop communicating directly with that individual and you communicate instead with the individual's lawyer. Are there exceptions? Depending on your jurisdiction, there may be. For example, in Florida, if there is a Florida statute authorizing the direct communication, then it's permissible to make that direct communication. I would advise best practices that even if such a statute applies, make sure, of course, that you're on all fours, that you meet the requirements of that statute. And I would also recommend as best practices that if you do meet all the requirements of that statute, that you contemporaneously copy that communication to the represented person's attorney. But without such a specific statute specifically applying to that specific circumstance, if you know an individual to be represented by an attorney, then you do not communicate with the individual, you communicate with their attorney. The end of chapter 18, in the end of subsection L, is what I like to call the bragging rule. The bragging rule. Yeah, the author of chapter 18 suggests that if you and I as a lawyer is dealing with somebody who's not a lawyer and that person also isn't represented by a lawyer, that we're obliged to disclose to that person that we are lawyers. We get to brag. It's a bragging rule. Brag about the fact that you're a lawyer. That's how I would summarize part 3, point 3 in part L of the last part of chapter 18. So as you can see, chapter 18 is kind of a hodgepodge mix of concepts we've already talked about and explored in far greater detail in other lectures. But it's a nice list of reminders, some important reminders nonetheless. So it was certainly worth your read. But I think for the most part, you'll agree with me that it wasn't news, it wasn't new information. Perhaps a new application of old information, but not a lot new there. But it was very important, so I think it was worth reading. The same can be said perhaps for lesson chapter 19 from our required reading, which talks about candor toward the tribunal. You got to have respect for a tribunal you're before. We call ourselves officers of the court. The public thinks of us as part of the judicial system. And indeed, we are. We are part of the judicial system. Act like it. Show respect for the system for which you are a part. That's what is embodied in rules like Model Rule 3.4 and Model Rule 3.5, and is surely embodied in every rule of professionalism of any jurisdiction of which you will be a member of the bar. Honesty, fairness, courtesy, to certain extents, are required by every binding jurisdiction. And the best way to do that, I think, is to avoid the ad hominem attacks, a Latin phrase. Avoid attacking the person. Attack the situation. Attack the law. But don't attack the lawmakers. Don't attack the individual. Don't attack the presiding judge who's presiding over the tribunal. I can't think of a situation where that becomes necessary. And that's true despite the fact that I myself am board by the Florida Bar in appellate practice. I do quite a bit of appellate work. I am very often on the appellant side. I am very often trying to overturn a judge's ruling and complaining about a judge or a judge's outcome or a judge's ruling to a higher court, to an appellate court. But I never see the need to mention the judge by name, even when the standard of review that I'm required to satisfy as appellant might be phrased as something like abuse of discretion. You know, you can satisfy even a standard like abuse of discretion without mentioning a presiding judge by name. I like to attack in my initial briefs, in my brief on behalf of the appellant, the order on appeal. I talk about how the order on appeal erred. I don't talk about how the trial judge erred. If the trial judge has a name, I certainly don't use the name. I don't say Judge so-and-so erred. I don't even say the judge erred. I say the order on appeal erred. Has the same meaning, has the same effect. Doesn't help me any to start throwing names in there and make ad hominem attacks. Doesn't help my client any. Doesn't help my case any. Doesn't help my client's cause any. I don't need to do that. Neither do you. The order on appeal is an abuse of discretion, is a great way to argue. Even in a standard like abuse of discretion, might be tempted to throw in a name. The appellate court knows who you're talking about. There's no need for you to sling mud. There's no need for you to talk about people. If it's the order you want reversed, you want the order reversed, right? It's the order that is the thorn in the appellant's side. It's not the judge. So show respect. Talk about the order. Talk about the law. You're saying a law is unconstitutional. You're saying that the office of so-and-so acted unconstitutionally, that the effect of the administrative rule was unconstitutional. No need to throw in names. You can always phrase it just as powerfully without mentioning the name. And in most circumstances, the name isn't the point anyway. The name is a tangent. You're distracting from the real issue at hand by throwing names out there. You want the appellate court to do something about the adverse outcome. You're not looking to remove a judge from a bench or get a judge sanctioned or punished. You're looking for a different outcome. And guess where you might just end up if you win that appeal? If you get a remand. Remand to where? To that court you were just complaining about, to that judge you were just challenging the order of. Wouldn't you be more comfortable on remand, having been the one that challenged the order instead of being the one that assaulted verbally in your argument the judge? Of course you would. So avoid it. Leave the names out. Same thing if, God forbid, you're in a situation where you've got to complain about the party. Complain about the plaintiff. Complain about the claimant. If you've got to use a name, why not throw a title out there? If they don't have a title because they're in an official role, such as president or spokesperson or director, or they at least have a courteous title. They're at least of courtesy, either Mr. or Ms. or Mrs. or right, doctor, or so avoid names if you can. And that, I think, is a fair summary of candor toward the tribunal, because that's a topic that came up again and again throughout so many lectures. Here we are with just 3 lectures other than today's lectures left in a 3-credit-hour semester. We've covered so much already, either deliberately or as a tangent from our deliberate topics. You've gotten such a great review in the written material, and Lord willing, in my lectures of these materials. So you probably are in a great position to answer this question. Is zealous representation and candor to the tribunal always at odds? Or can the two coexist? And I respectfully suggest that they can coexist, that they need not be at odds. We can be zealous advocates for our clients without ever breaching our duty of candor to the tribunal. And in our next class, please be prepared for me to drill you insofar as I will give you hypotheticals in a drill kind of format where I will ask you under that hypothetical, what do you do to be both a zealous advocate and to maintain your duty of candor to the tribunal? Be ready for that one-on-one discussion when in our next class, you'll all be with me through your webcams, and I'll be able to ask you one-on-one on the spot for these kinds of answers. Until that time, if I've left any questions unanswered, please reach out to me and communicate with me in the usual way. I'm always happy to hear from you, and I always enjoy answering your questions. And until I hear from you and until we gather again, may the Lord continue to bless us all. Thank you for taking my class. I hope I'm of good service to you. Good night.